in session. You may be seated.
Okay, the next case on the docket is Almagro versus School Board of Miami-Dade County. Counsel, I believe you've asked for 3 minutes of rebuttal.
That's correct, Your Honor.
And you may begin when you're ready.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court, Craig Frager on behalf of Tania Almagro and 25 other Miami-Dade County school teachers. The teachers appealed dismissal and summary judgment of their claims against Miami-Dade County School Board for violation of Section 1012.22, subsection 1, paragraph C of Florida statutes, and denial of summary judgment for the teachers on the board's liability under the statute. Your Honors, this case turns on the meaning of, quote, grandfathered salary schedule, close quote, as defined in the statute. I say it turns on this because, as I will explain, under a straightforward application of the definition, the board's actions are in violation of the statute, the teacher's employment contracts, and the teacher's rights to substantive due process under Article 1, Section 9 of the Florida Constitution. In addition, application of this definition shows the teacher's claims are not subject to the board's affirmative defenses.
So, counsel, before you go further, what is the relief in the operative complaint that your clients sought?
The relief that that they saw was the difference between what they would have earned under the grandfathered salary schedule and what they did earn.
So had just so I'm clear, the difference between what they would have earned had the school board complied with the statute.
Correct.
And what they did earn.
Correct.
Okay. Is there anything in Section 1012.22 that contains an enforcement mechanism or contains a private cause of action or something that would authorize this type of private monetary relief for a violation by the school district of the statute?
Yes, Your Honor. We believe first that there are two counts that should be considered, both private right of action and breach of the teacher's individual employment contracts. The first is the right of action implied by the court, and the legal precedent requires you to look at text, context, and purpose to determine the legislature's intent. The lower court only looked at text and said, well, I don't see a right of action here in the statute, therefore there's none.
But isn't that kind of basically judicial philosophy these days? You look at the text, you don't actually look at legislative intent.
Your Honor, there's colors of gray in that, but I understand that private right of action is a disfavored thing these days, but it's still available. The Supreme Court has never renounced it or abrogated it. The legislature has never abrogated it. And just looking at text and saying, well, I don't see it saying you have private right of action, is circular logic. The whole idea of implying a right of action is it's not there. It should have been there. By rights, it should be there. The legislature obviously must have intended it, and for reasons that we don't know, didn't put it in there. But the reasons can be as simple as, well, we thought, you know, if we set it from up on high, everyone would comply. We never anticipated that a school board would just say, we're not going to follow this.
But doesn't that make it a deadline then?
Well, no. The whole deadline analysis betrays a fundamental misunderstanding of the statute. The statute defines grandfathered salary schedule as the salary schedule or schedules adopted by a district school board before July 1st, 2014. The school board had a salary schedule. All school boards had a salary schedule. The legislature knew you would have to have a salary schedule in effect. All they said was, whatever you have in effect before July 1st, 2014 is the grandfathered salary schedule. So there's really no deadline per se. It's just, by operation of law, whatever salary schedule you have as of July 1st, 2014, an anniversary today actually, whatever you have by July 1st, 2014 is the grandfathered salary schedule. It's defined. It's a defined term. Where the legislature goes to the trouble of defining a term, the court has no leeway to, you know, shade it or, you know, talk about, well, maybe they meant this and that, but they didn't say it right. The language is clear. We go through the linguistic, grammatical reasons why it's clear in our brief, But in short, it says the salary schedule of schedules. It refers to a specific thing adopted within a specific time frame from when the statute was enacted until July 1st, 2014. That's plenty of time for the school board to bargain for a new salary schedule, which they did. The 2013-14 salary schedule was in effect before July 1st, 2014, on July 1st, 2014, and for almost 4 months after July 1st, 2014. So did they miss a deadline? No. They just, what do you call it when they do what the statute requires and then 4 months later decide to do something else? I don't call it missing a deadline.
Well, each of your clients signed a professional service contract of employment
Correct.
that specifically identifies the salary that they will receive for that upcoming year.
Well, actually, Your Honor, most of those salaries are no longer in effect. Professional service contracts, as you know, renew annually.
Right.
So they're evergreen, but every year it's a new contract.
Right.
And they refer to the salary schedule in effect at that time to incorporate into what their salaries are. You
But
may
it didn't say shall be paid a salary in the sum of blank payable in 25 biweekly payments?
Yeah, that's superseded by the next salary schedule. Someone who was hired 20 years ago may have a professional service contract that says you get $30,000 a year, but you look at what they're being paid today, and it's $60,000 a year. And the reason is because they've had other salary schedules since then that have raised the rate of pay. Now, the thing we object to is it's always been the grandfathered schedule as a step salary schedule. Years of service you put in, you get a bigger raise. They've completely done away with that altogether. Now they have the min-max schedule for everybody. So even their, far-fetched interpretation of the statute that, well, maybe it grandfathered a regime, even they didn't follow it. So, yes, the professional service contracts do specify a starting salary, but that's long gone for all of them. And it's interesting that the court accepted incorporation of the current salary schedules to those contracts, but yet denigrated incorporation as a, quote, far-fetched theory when we talk about incorporating the grandfathered salary schedule. Incorporation is not a far-fetched theory. We've cited to the court numerous cases, including cases from this court, where they say it's a staple of statutory interpretation. Their point is, well, you don't use it to contradict a contract. We've said cases where it does contradict a contract. In insurance cases where the insurance policy provides one definition, but the statute requires another, that overrides the contract. In addition, because of the statute, forgive me, because of 447-309, subsection 3, any collective bargaining term that is in conflict with the statute is ineffective. So the subsequent salary schedules after the 2013-14 schedule were void ab initio. So there's no conflict with the contracts because what they were trying to incorporate legally doesn't exist. May I continue?
Yeah, absolutely.
Okay, so in addition, Your Honor, Judge Gooden, to the implied prior right of action, okay, there is a clue, okay, if you're going to look at beyond text to context and purpose, there's a provision of the statute that talks about what the statute requires, and that's section 101.221C. Then if you look at 1D, right after that, it says that the teachers must be given a written employment contract. So that indicates, we believe, a legislative intention to allow suits to enforce the 101.22.
I'm confused. Didn't your clients every year from before July 1st, 2014 and after July 1st, 2014 execute contracts?
Well,
There's not a one contract they sign when they're hired.
Right.
And that contract is never superseded by another contract. They're annual contracts that are signed by your client.
Well, the professional service contracts renew every year, and it's our position that that starts a new contract period. So therefore,
Do they sign a new document?
They don't sign a new document as their professional service. If they're an annual employee, they sign an annual contract every year. At least they're supposed to. We've had trouble getting the actual copies of all of the contracts for all of our clients. I'm not sure what that's about. But the point is that if you look at 1012.22 subsection 1 paragraph D, okay, then it says that there's a right to get a written employment contract. And the thing is, if you look
But
at...
that doesn't use the word right.
Well, but here's the thing. An employment contract connotes rights. The contract is ineffective unless it conveys some rights to the parties. But if you look at the statute, there's another statute in the Florida statutes, and I have the citation here, if you want to bear with me. There's another statute separate from 101.222, which requires the teachers get a written employment contract. So why would the legislature say it twice? The law doesn't presume useless words or duplication. The point of incorporating a written contract requirement within 101.222 itself, we believe emphasizes that there is a right of action. Not only that, but there's a right of action under the contract itself. And that gets us into the law on incorporation, which requires that the court look at the contract, but where it either has no terms, which in this case, those salary schedules are ultra vires, or there's some uncertainty or conflict, you look at the statute controls. Parties can't contract away a statutory duty. So if the statute requires grandfathering of the 2013-14 salary schedule, which we believe it must under the plain language of the statute, then that is the salary schedule that should be incorporated into each employment contract. Once you do that, obviously there's a claim for breach of contract.
Can we address sovereign immunity?
Sure.
Can you explain how your clients kind of overcome that?
Well, there's three ways, Your Honor. First is ultra vires. We believe that when the legislature said you must have a grandfathered salary schedule, then any schedules adopted after the 2013-14 schedule are themselves ultra vires. And there's case law that we cite in our brief that says that, this is longstanding case law from Florida courts going back to the 1920s to the present, and we cite the Sarasota Doctors Hospital case as a very recent case from like a year ago, which says that where the government acts ultra vires, then sovereign immunity, it's not a question of implied waiver, it's a question of it doesn't even apply. It's an exemption from sovereign immunity because an ultra vires act is considered not an act of the sovereign. The second point is a breach of contract action is, of course, an implied exception to sovereign immunity, and the lower court was wrong to say that that exemption doesn't apply to implied terms of contract. The Florida Supreme Court has said in the ContraPoint case that they, in City of Tallahassee, said that it applies to both express or implied terms because they approved the Champaign-Weber case. And then in ContraPoint, they came out directly and said, we modified City of Tallahassee to include implied as well as express terms, which is logical because the whole basis for the exemption from sovereign immunity, the implied waiver, is mutuality of contract. You can't have one party being bound by both express and implied terms implied by law, and then the state saying, well, you can't enforce any implied terms against us, we have sovereign immunity. So that's the second way to overcome sovereign immunity. And the third, of course, is the constitutional claim. The lower court recognized that constitutional claims by their nature are not subject to sovereign immunity. The sovereign can't set up a constitutional framework to restrict itself and other power goes to the people and then say the people can't sue for violation of the Constitution.
Counsel, we brought you way over, but we'll give you 2 minutes of rebuttal.
I appreciate that, Your Honor. Thank you very much.
Hear from the school board.
May it please the court, Ellie Nyberger for the School Board of Miami-Dade County. The 2011 Student Success Act made significant policy reforms to improve teaching quality. And it did this by eliminating tenure and requiring that teachers be paid based on performance of their students. What we're here about today is the provisions of the statute which recognize that tenured teachers are not going to be subject to those changes. Those changes are going to be prospective. The appellant's argument that by operation of law, the salary schedule that would apply to the tenured teachers that aren't going to be subject to the new performance schedule, by operation of law, whatever existed on the date, July 1st, 2014, became fixed in time. That specific salary schedule with those specific dollars and cents governed the teachers that were hired before July 2014, forever in time. And not just that because there's a relationship between the performance pay teachers on that performance-based salary schedule and the grandfathered salary schedule that requires the performance teachers to always have the pay for annual increases higher than the highest pay under the grandfather schedule. So it also impacts the second schedule. Now,
Wait, is it contested that the county violated, or the school board violated the statute by not promulgating the grandfathered salary schedule prior to July 1st, 2014?
that is correct. There's no dispute that the school board did not adopt a grandfathered salary schedule under paragraph 4 of the statute.
So what is an aggrieved teacher's remedy?
The 2014 date is not a jurisdictional deadline. It recognizes no consequences for a violation. This is the McIntosh case from the U.S. Supreme Court cited in our brief. There are, just because a deadline, a time period in a statute is mandatory, doesn't mean that it is jurisdictional, that it removes power to do things. Here, the specific thing that the legislature mandated that school districts do is to adopt these two salary schedules. The consequence that the appellants asked the court to apply, to read into this statute, that if you don't adopt something by that date, it's the existing, whatever it was in existence is locked in, that would be a significant abrogation of, it would negate what the legislature compelled in the first place. So where there's no consequences in the statute, particularly in cases where there's, it's a legislative mandate at issue, the law does not supply a consequence, especially not the one that the appellants advocate here, which is then you just can't do what exactly it is that the legislator wanted. In this significant policy reform, you can't do it at all. And you're attacking...
Hypothetically, could the Florida Department of Education have brought an enforcement action against the school district?
If we're not standing here today, and because now there are those two salary schedules adopted, it's possible that a suit to compel the performance of that obligation could have been brought in some fashion, but that is far cry from what the appellants are doing here, which is to seek substantial damages, ongoing prospective and retroactive monetary payments that are just flatly contrary to the legislative intent, that it has never been the case that a salary schedule has been required to just be fixed in time. Again, it's nowhere in the statute. The appellants rewrite the statute in a couple of significant ways. First, they ignore the fact that it includes both of the provisions use the word adoption. It requires the school board, its legislative body, governing body, to take affirmative action to adopt those salary schedules. They also, looking at the definition of the grandfathered salary schedule, they stop before the end of the definition. The definition is the grandfathered salary schedule means the salary schedule or schedules adopted by a district school board before July 1, 2014, pursuant to subparagraph 4. So that's the next provision, the operative provision, which provides, again, that that the district school board shall adopt a salary schedule that's going to be used for the teachers hired before July 1st, 2014.
So how do you address your colleague's argument that there's an implied private right of action, otherwise the legislature would not have placed these very specific mandates on the school district?
So the notion of implied right of action is wholly contrary to the doctrine of sovereign immunity, which requires a clear, express, unequivocal statutory waiver by the legislature. The courts can't read implied waivers into a statute. In fact, an argument that an implied waiver exists would just
Well, your colleague argues, if I understand the argument, that the incorporation provision of the contract then creates an express contract. So under Pan Am, there's no real sovereign immunity issue. This is just a contract enforcement action, and the contract adopts in toto the statute and all other rules and everything. So it's your colleague argues it's not really a sovereign immunity issue, it's more of a breach of contract issue.
So a general reference in the contract, that one pager to just all applicable laws, that cannot override the express terms on that page, which the plaintiffs, appellants signed, saying what their salary was for that year. It also can't override the collective bargaining agreements that they are bound by.
Well, that was a question I had for your colleague, and I probably didn't word it correctly. But my understanding is that every year, each of the plaintiffs signs a new one-page contract. Is that not accurate?
No, that is correct. It's a form. I believe that it's prescribed by the state agency, by the Department of Education, and the statute says what it provides. It does not supplant the collective bargaining agreement. It is to provide, the statute provides that there's a 1 year period that you're going to have this contract for. Even if it's subject to renewal, it still has to be, yes, like a separate one each year. But this collective bargaining agreement is in place, it's incorporated into that term. The incorporation of just any Florida law in general is not enough to override the express terms of the collective bargaining and express terms, written terms of that page itself. Now, there's no dispute that any contract is subject to law, but the remedy would not be to then write in to cross out the express terms of that written contract and write in the desired terms. It might be a basis to invalidate a contract, but that's not what they're arguing here. And in any event, there's no basis to invalidate it because their arguments here are, again, just at every step inconsistent with the plain text of the statute. Now, going back to the missed deadline, there's no dispute that when the schedules were adopted, they don't claim that in that intermediate period that the grandfathered teachers, the pre-July 2014 teachers, that they were not given their salaries that they were entitled to under those schedules. The prior structure, the school board didn't subject them to performance pay schedules or anything contrary to what they were entitled to. So the fact that there was not that it took longer for the school board and the labor union to actually reach an agreement. It did not prejudice the teachers, and what they seek to do is just attach radical, substantial consequences to not having that schedule adopted. If the legislature intended those to not just to subject the school board to that liability, but to also impact the performance-based salary, which is just squarely, there's interconnection. You can't separate the two to say that the grandfather schedule is this deemed by operation of law adopted. It makes this performance salary schedule subject to it. These are not intended consequences. If the legislature intended it, it would have said it.
So what did the legislature intend with this legislation? What were they trying to do? They were moving away from tenure towards a performance-based. But when this discussion of grandfathered salary schedule, what was the purpose of that?
Sure. So in 2011, when this was adopted, the intent was to say that the tenured teachers are not going to be subject to the. So
they're not going to be hurt by this change.
I'm sorry?
They're not going to be hurt. The tenured teachers will not be hurt by this change to performance-based.
It does not apply to them under.
Is that the intent of the act?
Absolutely. It is to preserve the existing structure. The grandfathered salary schedule is the whatever structure was in place before. So,
they would be, the tenured professors, even though there's a movement towards performance-based pay, they would still receive the same salary?
Correct. They would still be subject to the same salary structures that they always have, subject to collective bargaining. And that salary
structure, when we talk about salary structure, that means if there were steps in the future, it would be based upon their salary as of the grandfather date?
No, there's the actual numbers are negotiated through the collective bargaining process with the labor union, pursuant to the Florida Constitution's right to collectively bargain over the terms and conditions of employment, and base salary is a mandatory term of bargaining, so it couldn't be removed from that constitutional requirement by just saying that we're fixing this in time, it can never be changed. The union represents the teachers, acts on their behalf, and bargains for them, and that is exactly what was done here, and what they're seeking to do is file, a class action to override what their lawful representative has negotiated on their behalf through that constitutional process. So again, it's never been the case that a specific salary schedule is frozen in time. It just never has been. So the legislative intent was to preserve the same structure that was in place before, as if the performance salary schedule was never adopted. These tenured teachers don't have to go to that. They don't have to be subject to that. If they can, if they'd like to, and there are incentives to, but they don't have to. They could stay just as they always were under that schedule for the remainder of their employment.
The legislature was in effect saying there'd be two avenues in terms of the collective bargaining. One would be for tenured professors who are electing not to be in the performance-based, and then the other would be for performance-based.
The statute says that if a teacher who's tenured elects to would like to go to the performance-based schedule, they have the right to do that. They can't go back to the grandfather schedule. It's a one-way election. And through the collective bargaining process, there's a procedure in the agreement to request to make that change to performance pay. And there are incentives. There's higher pay available for highly effective teachers under the performance pay. So there is incentive, but it's by no means required for tenured teachers.
So what did the school board fail to do under the statute?
The statute does say that these two schedules should have been needed to be adopted by July 1st, 2014. the school board's position is this is not something you can do unilaterally, required to bargain with the union about it. This was not accomplished by that date, but it does not negate its ability to do what it ultimately did, which is adopt salary schedules which comply with the statute, as the legislature intended to do as part of this overhaul of the teacher policy system.
One last question. So if we would adopt and agree with the appellant, doesn't that run us into this, because there's a requirement basically to bargain, couldn't the teachers union delay that bargaining and drag you past the deadline on purpose, and then all of a sudden, gotcha, I have a cause of action?
So that's a very good point. It could not have been accomplished by the school board unilaterally adopting this. It had to have been through the collective bargaining process. And so not suggesting that was done here, but yes, it was not something it could have done on its own. And again, they did ultimately reach agreement. No rights were harmed in the meantime. They got paid just what they would have been under the same salary structure as always.
Thank you, counsel. We
you,
brought
Judge.
you over. We'll give the appellant a couple more minutes, so the appellant will have 5 minutes.
Oh, thank you very much, Your Honor. I greatly appreciate that. Give me 1 second. A few points I'd like to touch on. First, we go into a lengthy explanation of why the board is wrong with their view of the statute on page 33 of our initial brief. It's several pages, but in some, they're arguing that there was a deadline due to subparagraph 4. But again, they're ignoring the text of the statute. The definition of grandfather schedule is a specific thing. The salary schedule is schedules adopted before July 1st, 2014. Then it says per paragraph, subparagraph 4 talks about the implementation of a grandfathered salary schedule. If you look at subparagraph 4, the title is grandfathered salary schedule. And then it says that, it merely says that the school board will adopt a salary schedule to be applied to teachers hired before July 1st, 2014. So it says you should apply a grandfathered salary schedule to the teachers hired before July 1st, 2014. It doesn't have a deadline for that at all. It references in its title the definition of grandfathered salary schedule. So you look at subparagraph 4 and say, okay, what do I have to apply to the teachers before July 1st, who are hired before July 1st, 2014? You go back to the definition, well, I have to apply the salary schedule of schedules adopted before July 1st, 2014. It's a specific thing, Your Honor. It's not some abstract concept like regime or past practice. A concrete term cannot, in English language, stand for a proxy for an indefinite term.
Were the schedules ultimately adopted through collective bargaining?
Yes.
Were they less than the schedules adopted by the district board before July 1st, 2014?
Well, they didn't adopt a replacement schedule until November 2014.
Yeah.
But the schedule in place on July 1st, 2014, again, was a step schedule that allowed increases in salary based on years of service. And every year you got a salary bump, and in later years, bigger bumps. And they've completely eliminated that. So even under the definition of, past practice or regime, it doesn't exist. They haven't maintained that either.
So you're saying the salary schedules that are adopted by the district court before July 1st, 2014 was a schedule, but it also scheduled future bumps.
Yes. In other words,
and it's the future bumps that have been eliminated.
Yes, and
that was
I'm sorry. Yes.
It's the future bumps that were eliminated by the collective bargaining agreement.
Well, also they use different numbers.
Am I right? Is that a yes or no?
That's correct, Your Honor. And in fact, the min-max schedule just says you're going to get like a 2% increase over last year, what you got last year, or a 3% increase across the board for everyone. Now, they sometimes make it a smaller bump for tenured teachers, professional service contract teachers than annual contract teachers, but it's still the same. You're just going to get a flat percentage increase now.
I don't know if this is in the record, but why would the union through the collective bargaining agree to give those teachers less? So
well,
other teachers could get more.
I can't read the union's mind, Your Honor. I do know that we've consulted with them. They don't want to intervene in this case one way or the other on either side. They have no, they don't have no dog in this fight because the statute doesn't require them to do anything. The onus is always on the board for every law that regulates employment practices and terms and conditions to reject any proposals that do not comply with the law.
But your clients are being compensated pursuant to the collective bargaining agreement that was negotiated between the school district and the union, correct?
Correct.
And to follow up on Judge Loeb's question, that collective bargain agreement that was negotiated bargained away the grandfathered salary schedule concept in 1012.22.
Correct, Your Honor.
So is your client's remedy a grievance with the union?
No, Your Honor, because an employment grievance is accusing the employer of breaching the contract. The employer didn't breach the contract. They followed the contract, at least what they thought was the contract. So there's no grievance to be filed here. The plaintiffs did go to
I guess
plaintiffs
I'm-
did go to to PERC before this, and were told they didn't have standing. So, there's no way to pursue the union other than a PERC charge or a grievance against the employer, which the union, first of all, wouldn't support. And even if they did, what is the grievance? There's no breach of contract per se for an arbitrator to look at. They look at the contract. Arbitrators are limited to the four corners of the contract. So,
Wouldn't the breach be, you're saying a breach against the union?
well, I'm saying that, did the union do something wrong that we could sue them for? And I'm saying
Arguably,
no.
I mean, if they agreed to something that violated the statute under your views, no?
Correct, but again, what's the remedy? The entity responsible for paying the salaries is the school board. The statute's requirements are solely on the school board. The school board's duty under 447 and 309, subsection 3, is to either reject the proposal or take it to the state legislature and ask them to grant them an exception, which wasn't done here.
Thank you, counsel. Thank you both. Very interesting case.
Thank you, Your Honor.